Now we'll talk about Principle 3, who are made liable. We discussed what torts are, the legal basis in Principle 1. Torts must cause damage, and when they cause damage, damages will be awarded. So we talked about types of damages in Principle 2. Now, who are made liable when damages are caused? This will be the topic of Principle 3. Now, general rule is it's that person who causes damage. He is the person obliged to pay for the damage done. But then, if you look at 2180, there is a vicarious liability. Father, mother, guardian for the minor or insane, employers for their employees, household helpers on the occasion of their functions, teachers for their pupils. Take note, I included 2184 here. The owner of the vehicle is solidarily liable if the owner is inside the vehicle. 2185, there's a presumption of negligence when violating a traffic regulation. Take note, I put it here because this is strict liability. I'll show strict liability in a bit. So under 2180, the general rule is if you prove that you observe due diligence to prevent damage, then you are not vicariously liable. Take note, if the employee causes damage and the employer pays for that, 2181 says the employer can recover from the employee. All right, so let's go back to this one. Say, for example, uh, an employer's driver was driving. The driver causes damage. General rule, when the employer observed due diligence to prevent damage, the employer can avoid vicarious liability. But take note, if the owner of the vehicle is inside the vehicle, then strict liability arises. I'll show you strict liability. Here are the provisions. So as a general rule, when strict tort is in play, the 2180 will not work. Here's an example. A father shows due diligence to prevent the falling of something from a building to cause damage. All right. So even if the father observed that, take note, there is a strict liability under 2193, heads of families, when things fall off the building. Take note, again, the employer of a driver may prove that he or she is not liable, vicariously liable, if he or she observed due diligence to prevent the damage of the driver. But if that owner of the vehicle was inside the vehicle, strict liability will arise. Okay, we look at, for example, a person who induces the violation of a contract. Take note, the general rule is it is the person who causes damage, meaning it is the person who violates the contract who should be liable. But because of 1314, a person who induces violation of the contract will be made liable. All right. So those are the dynamics. There's the general rule on who should be made liable. Who should be made liable? The person causing damage. Except that if there's vicarious liability found in 2180. Take note, however, if strict tort is applicable under these provisions, 2180 will not be applicable. All right, let's give an example for that. A third person who induces another to violate his contract, you may think that since this person merely induced but did not violate his contract, should not be liable. So you might think, well, personally, I think, no, this is what the question is asking. I think the trick here is the examiner wants you to believe that it is the person who violated the contract. All right. So who should be made liable? But because of 1314, strict liability, I think the answer should be it is even if the person merely induces another because of 1314, that person should be made liable. Oh yeah, when we see each other, we can discuss this. Yeah, we can argue about it. That'll be fine. All right, so here's another question from 2015. There's a bus driver who ran over a boy. He sued the criminal case against the driver was filed. He got convicted, paid 2 million in actual moral damages to the parents. Okay. Without trying to find out if the driver had assets, the parents of the boy filed a civil action against the bus company to make it directly liable. I thought the phrasing was quite tricky because the facts say a criminal case was already filed. Anyway, let's answer the question, will this action prosper? And then this follow-up question is, if the boy does not wish to file a separate civil action, can they still make the bus company liable? And I think there's supposed to be a question C. If so, what is the nature of the employer's liability? And how may civil damages be awarded? I think that's the third question there. Anyway, let's look at it. Let's chop it up. Would action prosper? If the parents of the boy do not wish to file a civil action, can they still make the bus company liable even if the driver cannot pay? If so, what is the nature of the employer's liability? All right. So this is my take. I believe the action will prosper, yes, because in principle 1.5, we talked about an independent civil action where if there are physical injuries, that is entirely separate and distinct from the criminal action. Some may say that rules of court, the civil case is impliedly instituted, but I think there's independent civil action. One may also argue, but Article 31 says only, but one may argue that because of Article 31, only since the civil action is based on the felony, um, then it should have been instituted already, right? So the point is in Article 31, uh, one may argue that, but the civil liability, civil action, is based on the act complained of as a felony. Therefore, you cannot uh, file an another action. But I think Article 33 says there's an independent civil action. We may argue about it. We can discuss it. If the parents of the boy do not wish to file a separate civil action against the bus company, can they still make the bus company liable if the driver cannot pay? Though I believe so, because Article 103 of the Revised Penal Code says subsidiary liability when the employee is insolvent. The question here is if the driver cannot pay the award for damages. I believe this is the responsive answer. We can discuss your thoughts on this. So, what is the nature of the employer's liability and how may civil damages be satisfied? Well, 2180 comes in. Employer will be liable based on 2180 in the performance of their functions. When will it arise? It will not arise. Employer's liability will not arise if the employer is able to show due diligence in the selection, supervision, and prevention of the damage. Right? Let's go to a 2010 bar exam. There was a 16-year-old boy with a student permit. We know that the student permit was the fault of the parents, all right, or caused by the parents. Now, he drove to school. In fact, the car was given by the parents. Now, they had a field trip. The teacher requested him to accommodate in his car 4 classmates because the van rented by the school was tight already. Now, Rosano, that 16-year-old, made the wrong maneuver, caused a collision with the Jeep. One of his classmates died. Who is liable for the death? How about the damage to the jeepney? You can analyze, but this is my take on this one. Who is liable? I think For the death of classmates, the teachers will be liable. They were exercising substitute parental authority under 2180. How about the damage to the jeepney? Maybe you can say the teachers also, but also I think you could say, you could quote 2180. It says parents or legal guardian who will be liable for the minor who was living in their company. So this is how I think you should approach this question. Okay. Now there's a 2009 bar exam. Romel was in the car by a driven by sorry. Romel was in Romel's private car. All right. This time the car was being driven by a driver. The driver hits pedestrian. Romel is not in the car. So is Romel liable for damages? And what if Romel was inside the car? Okay. So I think Romel will not be liable because I don't see any fact saying he was negligent. But if supposing there was the fact say it was negligent, Rommel will be liable as an employer under 2180. Now, what if Rommel was inside the car? Take note, 2180, the general rules in 2180 will not apply because there's strict liability. 2184, Rommel will be solidarily liable. All right. Suddenly, out of this question, I think you may want to review again the general rule 20, under 2176, the vicarious liability under 2180, and the interplay between that and strict torts. Okay, we'll go to principle 4 now.